Welcome, everyone. We'll just give it a minute here while people join. All right, let's go ahead and get started. I am Jeremy Rogers, the Director of Legal Affairs and Public Policy here at Oregon Realtors. And I was heavily involved in the development of our forms program and drafting of the forms, along with a committee of principal brokers from around the state that we have, and also Nicholas Peasley, our staff attorney. Today, we're talking about new construction sales on the Oregon Realtors forms. This is not going to be sort of a masterclass in construction contractor law and construction lien law. We're going to touch on those subjects as they relate to the form, but our hope is that at the end of this hour, you'll feel comfortable initiating a purchase or sale on for new construction on the Oregon Realtors forms, and really trying to focus on teaching you how to use the form. We likely will follow up with additional webinars and programs on other aspects of new construction law. So if there are topics that you do want us to dive into more deeply than we do today, let us know and we'd be happy to put those presentations on as well. I'm going to start off by just giving a brief overview of some of the resources that are available to you beyond this course to help you learn how to use the Oregon Realtors forms. And then we will dive in to how to complete a new construction contract using Oregon Realtors forms. Feel free to ask questions. If you do have questions, happy Friday to everyone as well. If you do have questions, it's a little bit easier if you put them in the Q&A as opposed to the chat, because then we can keep track of those that we've answered and those that we haven't. So try to do that, and we'll get going. So, okay. First thing I want to do is just talk to you a little bit about the training resources that are available to you from Oregon Realtors. Hopefully you've all spent time on our website. It's orforms.org is the URL. Please bookmark that. If you go to that website, you'll see there is a training tab. And if you click that training tab, you'll see a variety of training options that are available to you. And I want to just talk briefly about each of those. So on the far left there, or I guess we'll start with this one. Live trainings and webinars, that's what you're taking today. We do a live training on a different form every Friday at 10 a.m. So check the schedule. If you click that button there, you'll see all the ones that are coming up, and you can sign up for any one of those. We also then record all of those and put them into our self-paced training library. Whether you do it live or you do it the self-paced training library, it will be for CE credit. It usually takes us a week or two to get them over into the self-paced training library. Okay. In addition to these weekly classes on different forms, we also have our baseline using Oregon Realtors forms course that's both available live and as a self-paced course. That is a training that uses different transaction scenarios to help you learn how to use the Oregon Realtors forms. Okay, it's based on a designed curriculum that we worked with professionals to develop, and it's taught by principal brokers rather than by your association staff attorneys. We have our virtual open house that takes place at 11 a.m. on Fridays, so it's right after this. So you're welcome to hop over. It is a different Zoom link. You can get that Zoom link by clicking on that virtual open house button on the website, and you can sign up for as many of those as you want. It's basically a drop-in opportunity to ask questions about the forms. So you can come with one question, you can come with many questions. Some people come just to listen to hear other people's questions to help them learn. So we welcome all of that. We'll just always be there for you at 11 a.m. on Fridays, where you'll be able to access an attorney to get questions answered related to the forms. Finally, we have our recorded tutorials. These are videos that are not for CE credit, typically shorter than the 50 minutes that is required for an hour of CE credit, but nevertheless, helpful information about our forms and about using our forms. So I encourage you to check those out as well. We also have what we call our guided forms library. So this is a video annotated version of each of our forms. So you'll see if you scroll down that training page, you'll come to this guided forms library. you'll see all of the forms listed. And if there's a green button there that says guided forms with videos, if you click on that, it will pull up a version of that form that has little play icons next to it. This is an example for the new construction addendum, which we're talking about today. If you click those little play icons, there's actually a video that will pop out and explain that section to you. So no fear, after we go through today's class, if you want to brush up, you always can use the video annotated form. And we have those up for, I think, almost all of our forms now. If not all, we're getting close to having those all up. We certainly do have it for new construction. All right, so let's talk about our approach to new construction sales with the Oregon Realtors forms. And if you've used the ORF forms, our approach is different. So what distinguishes our approach? Well, first, with our sale agreements and contracts, a new construction sale is accomplished with the base sale agreement that you're using, typically the Form 1.1 residential purchase and sale agreement. However, it could also be, for example, an agricultural purchase and sale agreement that also includes a new home. But you'd use the appropriate base sale agreement. Then you'd add in the new construction addendum to complete the new construction transaction. We do not have a specific new construction sale agreement. It's always going to be the base sale agreement plus the new construction addendum. Mention that. Some of the benefits that we see of this approach as opposed to having a new construction sale agreement, it's more flexible and adaptable. I mentioned before, usually it's residential, but perhaps there's an agricultural sale that also includes a new home. In that case, we did not want you having to sort of scratch your head about which form, which sale agreement should I be using. You use the base sale agreement that's appropriate to your transaction, and you can always bring in the new construction addendum, okay? That makes it easier. You don't have to kind of wonder which form to start with. Also requires less learning of different sale agreements. You can become very familiar with the base residential sale agreement, know it like the back of your hand, and you don't have to feel like you also have to learn another base sale agreement to that degree, because you're just going to be using that residential sale agreement and then adding in the extra pieces that go along with the new construction transaction. So we thought that would be easier for people to learn, take advantage of the fact that you are all going to become experts in the residential sale agreement because you're using that on a daily basis. So in the residential sale agreement, we do reference the new construction addendum. So when you're filling out that residential sale agreement with your client, question 10 on the first page of the actual sale agreement, this is after the final agency acknowledgement, is going to ask whether the home is new construction or whether there is more than $50,000 in remodeling within 90 days of closing. If you answer yes to that question, then it's going to instruct you to use Form 4.1. Now we'll talk a little bit more about what does new construction mean, why do we talk about 50,000 in remodeling? We'll get to that. But if either of those apply, you would check yes and use Form 4.1. My understanding is that if you are using Zip Forms as your platform, when you check that box yes, Form 4.1 will automatically come into your file. They've set it up so that if there is a form that's needed, when you check a box, then that form comes in to that file if the form is referenced here like it is for new construction. We also later in the sale agreement, section 35, reference this to just reiterate and ensure that the new construction addendum actually does get incorporated into the sale agreement. If it's new construction or if there is the $50,000 in remodeling within 90 days closing. Wanted to add that in just to be sure that people don't miss it. And also with this whole 50,000 in remodeling piece, there could be a situation where that arises later in the transaction where the parties didn't know that at first. We also have this in our agricultural sale agreement. Okay, section 14 of our agricultural sale agreement asks the same question about whether there's a home with new construction or more than 50,000 in remodeling. If yes, you're going to use the Form 4.1. We also have the section 47, which is another reiteration and reminder of the need to use the document. So now let's take a look at the actual Form 4.1 new construction addendum. So here we start with, as we do with all of our addenda, we have a sale agreement number space on the top left corner for you to write in the sale agreement number and associate this document with that sale agreement. Then we have our property address or description field, which we have on all of our addenda as well. and the names of the parties. Of course, you know, we have space for 4 buyers and 4 sellers in all of our documents. Now, here we get to sort of the use case for this document. So here's where you're going to select which particular situation applies here, you know, which reason for your use of this new construction addendum. So there are 3 scenarios that we lay out here. Okay. One is that construction is or will be completed within 90 calendar days before closing. Okay, and the reason why that's important, and we'll talk more about this, is that that is going to trigger the application of the Oregon Homebuyer Protection Act. Construction is or will be completed more than 90 calendar days before closing. Okay, because in that case, the Oregon Homebuyer Protection Act would not apply. Or if there is $50,000 or more in improvement costs that have or will be incurred within 90 calendar days before closing, again, that is going to trigger the Oregon Homebuyer Protection Act. So why is this 90 calendar day thing important? Because in front of you here, you see the Oregon Homebuyer Protection Act, which is ORS 87.007, which requires sellers to protect buyers from construction liens. And you will see that section A there says that a new single family residence or a single family residence where the sales price is $50,000 or more for original construction, or the contract price is $50,000 or more for improvements to the residence completed within 3 months before the date the property is sold. Okay, so that's why we are lumping in that major remodeling within 90 days closing to our new construction sale, because in many respects, it operates like a new construction sale, at least with respect to the Oregon Homebuyer Protection Act. We'll talk more about the requirements of the Oregon Homebuyer Protection Act here in a bit. We have a section on that in the document. Other thing to note, if that is the case, that it's the $50,000 or more in improvement costs within 90 calendar days before closing, then several sections of this document are not going to apply. So we just call that out right here. Section 9 through 16 are those sections of the document that really do just apply to actual new construction, not to that remodeling scenario. The other thing to mention is that we're really talking about 90 calendar days before closing. So if more than $50,000 in improvement costs were completed 45 days ago, and you're going to close 60 days out, okay, well, that is 105 days. That's not within 90 days of closing. Okay, so the instances where this will occur within 90 days of closing are probably pretty limited given the time it takes to close a transaction. So let's just talk about, and I don't want to spend too much time on this because it's down in the weeds, but sometimes people ask, you know, we use these words like, you know, when construction was completed, was construction completed within 90 days? What does it mean to be completed? So I'm just pointing out to you what some of the laws say about that issue. So we reference in the document ORS 87.045 to define what completion means. And essentially what that statute says is that the improvement is substantially complete, which now of course means we need to know what substantially complete means. So we'll talk about that. Or that a completion notice has been posted or recorded. That is really the best thing when people post and record with the county recording office these completion notices, because then everyone in the world knows when completion was done. So that hopefully is the situation. And that just explains a little bit more there about posting and recording a completion notice. But what is substantial completion? Okay, well, substantial completion means that a person in the position of the owner would reasonably conclude that the contractor had fulfilled its obligations under the contract and final payment was due, or absent any evidence to the contrary. It could be that the substantial completion could be on the first of any of the following: final inspection, certificate of occupancy issued, habitability of the structure, okay, or all or most of the payments were made. So essentially, we don't know exactly what substantial completion means. There's a lot of wiggle room in there. I don't think it's ever going to really be a critical thing for you in determining whether to use a document or how to fill it out. If there's any ambiguity or unsurety about how close you are to 90 days, you should just presume that it's going to be done within 90 days of closing, so that you follow the Home Buyer Protection Act laws, because you don't want to run afoul of those laws. So that would be my suggestion if you're sort of on the fence. Just so you all know, there's another definition of substantial completion that's different than the one I just described, which is used by the courts related to bringing an act, bringing a lawsuit against a contractor. So the whole substantial completion definition is a bit of a moving target. So that was just a bit of a side for those who are interested in that. But back to the form, the next section that we have is the early issue title insurance section. Okay, so we wanted to include this in here. It often will be required by a lender. And here you have the option to select whether it will be paid for by the buyer or the seller. What is early issue title insurance? Okay, it's an additional title insurance policy that's required by lenders for borrowers who are taking out a new loan secured by a new construction home. Okay, protects you and the lender from any mechanics liens filed against the property. This is a bit of outdated information here, so I don't know if these numbers are still accurate, but you can see at least a few years ago, cost of the insurance typically around $200 to $250 per $1,000 of loan amount. Now, if the home purchase closes after the lien waiver period is over, which is really 75 days, okay, is the actual statute in terms of when can a lien be perfected, 75 days after completion, then you probably will be able to waive this requirement, but you need to work with your lender on that, okay? And some people ask, well, if the statute's 75 days to file a lien, why is this 90-day issue there for the Home Buyer Protection Act? It's just giving a little bit of wiggle room, okay, to make sure that we're actually protecting buyers. Okay, so the next section here is going to be the seller status. This is really, really important. I think people run afoul of this all the time. If a seller is selling new construction or homes that have been substantially remodeled, significantly overhauled as a business, they need to be a licensed contractor or developer. Okay, so if you're a home flipper or you're working with home flippers and they do this, they put in $50,000 to $100,000 in remodeling to homes as a matter of course and sell multiple of those in a year, they should be a licensed developer. Okay, and one of the reasons why this is important is because for a buyer to be able to bring a claim against a seller with the construction contractors board, the seller has to be a licensed contractor. Now, if the seller was supposed to be a licensed contractor, and by the way, a licensed developer is a subset of contractor's license. Okay, so if it's a home flipper who kind of manages everything but doesn't, really do the contracting work, they would be a developer. But the CCB could still punish that person for not having a license when they should have had it. But the buyer's remedy, the buyer's ability to go to the CCB and say, hey, I got screwed over by this contractor. You can't do that unless the person's actually a contractor. Okay, so we want to protect buyers here. We also want to make sure sellers aren't in the business of selling new construction without a license if they don't realize that. So here, the seller is going to have to attest that they are a licensed contractor, okay, whether they're performing or hiring others to perform the construction, and to provide their CCB number. Or if they're not a licensed contractor, that's the second option, the seller is going to make representations that give assurances that the seller is not required to be a licensed contractor. Okay, so here we want to know if the seller, the seller is going to attest they did not arrange or perform to arrange for the construction, alteration, or repairs of the property in pursuit of an independent business for compensation. If they did that, they need to be a contractor. They haven't done contracted for more than they haven't contracted for one or more licensed contractors to perform work in the same calendar year on more than 3 existing residential structures. If they had done that, they would need to be a licensed contractor. And if they're not a licensed contractor, they are going to guarantee that any work that they was done that required a building permit was performed by and under the direction of a licensed residential general contractor. Okay, so you can still use the agreement if the seller is not a licensed contractor, but the seller is going to be making all of these representations about their status, that they did not need to be a licensed contractor and that they have used contractors where required. Now, just a note there at the bottom in bold, we do want the buyer to be aware that if the seller is not a licensed contractor, there could be limitations in the ability to pursue the seller at the Construction Contractors Board. Okay, so we'll make that buyer aware of that. Buyer should consult an attorney if they have questions about that and what it means for their remedies if they feel like something went wrong with the construction. That is section 5. Looks like I had highlighted those, didn't realize it. All right. And this is just a little bit more on that. These are the jurisdictional requirements for filing a complaint with the CCB. Okay, and what you'll see here is that a direct contractual relationship based on a contract entered into by the complainant and the respondent or their agents is a requirement, okay, or a real estate purchase conditioned upon repairs made by the respondent. So we're going to get into the next section, and in that section, we talk a lot about this issue and have some sort of backup protections for a buyer if the seller was not a licensed contractor, where the seller is going to have to sort of bring the buyer into the contract that they had with any contractors, such that the buyer would still be able to pursue remedies due to this requirement that there be a contract in place between the person bringing the complaint. Okay, so now that last one's good to know. It's not really relevant to this particular thing, but in a regular sale, if the seller or if a contractor is doing repairs based upon a repair request made by the buyer as part of the negotiations of that sale, the buyer actually is able to bring a claim against that contractor with the CCB. That's not for this, that's for a regular sale with repairs negotiated, but helpful for you to know in your other transactions. So let's talk about section 6. These are additional representations that the seller is going to be making regarding contractors. We're going to ask that the seller, if they're a contractor, and all contractors, okay, be licensed and bonded with appropriate endorsements from the CCB. They're in compliance with all state and federal laws. They have not been sanctioned by the CCB, and they have no pending complaints with the CCB. They've not been found guilty of any civil or criminal construction-related violations, and there are no pending violations. They are insured for public liability, personal injury, workers' comp, property damage, that their bonds and insurance policies have not been reduced, exhausted, or canceled, that they will only use licensed subcontractors who have the appropriate endorsements. Okay, so those promises are all being made in the contract by the seller to the buyer. If any of those statements are not true, okay, the seller needs to disclose what is not true about them prior to entering the agreement. Okay, so we do have some additional provisions, lines later in the document. They could do it there. They could use a blank addendum, okay, but there has to be a written statement from the seller indicating to the buyer if anything up there we just talked about that's in that section 6 is not true. And the seller must update the buyer if they learn of anything that makes any of those representations false. Okay, so this is really important. This is an ongoing duty, and the seller is going to have to notify the buyer, including things like if they learn that there's a complaint now against one of the contractors and they become aware of that, that's something they would need to tell the buyer. Now, this is what we were talking about before. So because the buyer would have to have a contractual relationship with a contractor in order to bring a claim against the contractor at the CCB, we want to try to connect the buyer to whatever contract exists between the seller and the contractor if the seller his or herself is not a contractor. If the seller is a contractor, then the buyer brings those claims against the seller, even if the seller had hired other contractors. But if the seller is not a contractor, we want to create that contractual privity between the buyer and the actual contractor, so they could bring a complaint to the CCB. So we provide two ways of doing that. Okay, so the seller is going to either provide the buyer written evidence that the contractors and the seller have expressly agreed in the construction contract that the buyer is a third-party beneficiary of the contract, and that buyer status as a third-party beneficiary cannot be revoked without buyer's written consent. Okay, so this would be where the contract itself is calling out the buyer as a beneficiary, so that when that buyer goes to the CCB, if they needed to, they could point to that contract and say, hey, I'm named in this contract as a beneficiary, I can bring this claim. Okay, the other option would be for seller, if the construction contract that the seller has with the contractor allows the seller to assign, okay, their rights to bring claims against the contractor to a third party, and that the seller will in fact assign those rights to the buyer prior to closing. Okay, so this is an extra layer of protection. It's probably not included in whatever you've been using previously on new construction, but we think it's really important, particularly for those situations where a buyer is going to enter a contract with a seller who is not a licensed contractor. Now, if the seller has either presented false information in this section 6, or they fail to update the buyer, if anything becomes untrue, then the buyer is going to have a right to terminate, and they'll be able to get all of their earnest money back. Of course, we have a Form 5.3 buyer's notice of termination. We're not talking about that today. We have classes on that, but that would be the form that you would use to terminate. Now, we also have a space here for the seller to provide the CCB numbers for the contractors, okay, and this that are used in the project. And this, of course, would allow the buyer to go look up those contractors to confirm their status, both as licensed and that they do not have complaints against. The next section, section 7, this is a provision probably not going to be used very often, but just alerts the parties that if buyer wanted to bring in any of their own contractors or subcontractors to do any work, they could only do that with the seller's written approval. And if they do that, the any negligent acts by the buyer's contractors are not going to provide the buyer an opportunity to terminate the sale agreement. Okay, if the buyer brought those contractors in, those contractors weren't licensed, or they didn't have their bonds, or they otherwise were out of compliance with those provisions in section 6, the buyer can't cry foul on that because the buyer is the one that brought those contractors in. So the next section we're going to talk about is the Home Buyer Protection Act. We talked about this earlier. This is why we ask about the whole 90-day issue. What is the Home Buyer Protection Act? It was passed in 2006. It requires sellers to protect buyers from potential construction liens. The seller has to choose one of 5 methods to protect the buyer, and then the seller provides the buyer with a CCB approved form specifying which method that they are using to protect the buyer. Okay, so what are those methods? So one is the purchase of title insurance on behalf of the buyer, and that title insurance policy will not have an exception for construction liens. Okay, so they would have to either purchase that title insurance policy that would cover the construction liens. They would have to retain an escrow an amount not less than 25% of the sale price. Okay, that's quite a bit. They could maintain a bond or letter of credit that is not less than 25% of the sale price. They could get waivers from every person that by law would be able to file a construction lien exceeding $5,000. Okay, so if they go and they talk to all the contractors and all the subcontractors and get written waivers that say that those contractors and subcontractors are attesting they are not going to bring forward a construction lien and are waiving their right to do so. Or if the sale completes after the deadline for perfecting the lien. Okay, so this is where if you're in that sort of 76 to 90 day window, one acceptable method for the seller to say, hey, we're actually closing 85 days after the completion of the construction, and so we are in compliance with the act. But you still would need, the seller would still need to send the notice. So the difference between being within 90 days and 95 days, if you're within 90 days, but you're within 76 to 90, one method of compliance would be filling out that CCB form that you have to give to the buyer saying, hey, we're closing 85 days after completion, and that's the way we're complying. If you were 96 days, you wouldn't even have to send that notice to the buyer, okay? Because you wouldn't even be within this regime. So that's sort of the difference between not even having to comply with this law or having to comply with the law, but complying by closing later than 75 days. Now, the next section is on the contractor's warranty. Okay, Oregon law requires contractors of new construction to make a written offer of warranty. Okay, however, the owner or first purchaser may refuse the offer of warranty. So here we are laying out the checkbox options for the parties to indicate what's going to be going on with the warranty. So either the buyer has received the seller's written offer of warranty and accepts it, they have received the seller's written offer of warranty and refuses it, or they have not yet received it and it shall be provided within a blank number of days. Parties can fill that in with the number of days that they feel is appropriate. Okay, the next section we have is our maintenance schedule section. New construction contractors are also required to provide a moisture intrusion and water damage document and recommended maintenance schedule for new construction. So we are indicating here that the seller must provide that to the buyer, and we are referencing the statutes and rules which lay out what that looks like. Now, if you go to the Construction Contractors Board website, they have template documents for all of these things. Okay, so that's super helpful. The next section in our document is related to the insulation disclosures. This is actually a federal law, not a state law, that requires home sellers to disclose the type, thickness, and R value of insulation installed in the house. Okay, now if the buyer signs this contract before the seller knows that information, okay, then the seller must follow up with that information as soon as it's known. Okay, but we do have the space here. We tried to provide enough space because you have to do this for each part of the house. So we've provided 4 different sections here to do this. If you need more, then you would just bring in our Form 2.2 general addendum to add the additional information. But we tried to make it easy by putting 4 and laying out the fields for the type, thickness, and R value, so you can just plug those in. Then we have section 12 here. This is indicating required Oregon disclosures. Okay, so for the most part, these are disclosures that a contractor has to give to the person who hired them. So in many cases, these are disclosures that are actually going to be given to the seller. Okay, but in some instances, if the buyer is purchasing the land and directing the purchase, the building of the construction, then those would be given directly to the buyer. But we've provided the link to the page on the Construction Contractors Board website that describes what those notices are and when they would need to be given. The next section is related to plans and specifications, and this actually is creating a contingency, okay, in some instances. So this is pretty important. So here the parties are going to have a few options. They can select the first option that the construction is already complete, okay, and so there is nothing's contingent on any additional plans or specifications. Alternatively, they may have already agreed to plans and specifications, in which case you would attach a document that includes what those agreed upon plans and specifications are, okay, and then they would become built into the contract. The third option, and this is where that contingency arises, if the parties have not yet agreed on those plans and specifications, the parties have an opportunity here to indicate how many days they would like to do that, to reach a written agreement on those plans and specifications. and any associated modifications to costs or deposit that would be part of that negotiation. And then if they are not able to come to an agreement within the time frame allotted here that you put into the contract, the buyer is going to be able to terminate, and they are going to be able to get all of their earnest money back. Okay, so this is pretty big additional contingency that comes along with use of the addendum, in addition to the ones provided in the base sale agreement. Now, at the end there, that's on the next page of the document, but it's on the same slide here, same section. Nothing here prevents buyer and seller, of course, from mutually agreeing to additional specifications or upgrades down the road. Okay, so people change their mind, and if they can come to an agreement about it, then great. You're going to be locked in. I mean, once you get past this period here and you've agreed to the plans and specifications, you're going to be locked into that by contract. But if later you mutually agree to change that or amend that, no problem. Okay. Now, of course, one party can't change or amend it because there's now already a contractual agreement. But if both parties want to change or amend it, that's okay. You just do it in writing and it would become part of the contract. So the next section is dealing with sort of modifying the appraisal deadline. So in the base sale agreement, there's a section that has a deadline for when the appraisal must be ordered. Okay, and in the residential sale agreement, the one of the options is that it is the day after the end of the due diligence contingency period. Okay, and we put that in the base sale agreement because typically that due diligence period is the period at the end of which, if the buyer's still in the deal, that means the buyer's committed and it makes sense to go ahead and order the appraisal. But here, it may be that the home is still under construction. Okay, and later on in this next section, it may even be that the buyer is going to be choosing a different inspection regime than the due diligence period that's in the base sale agreement. So here we're giving the parties the opportunity, or indicating that if the parties have included the plans and specifications contingency, the appraisal deadline is going to be the business day following the end of the plans and specifications contingency. Okay, because you got to get that thing ordered at some point. You don't want to delay, but you don't want to order it before you know that you're really committed to the deal. So here we're saying, look, after you've agreed to those upgrades and any modifications in price based on those upgrades, then makes sense to order the appraisal at that point. The next section we have here is about our professional inspections upon completion. There's two options. You can maintain the due diligence contingency. So that's what you would use, certainly, if the construction is already completed. Okay, if the construction is already completed, you're not waiting for anything. That base sale agreement that you're using has a due diligence contingency where you're picking a time frame to do the due diligence on the property, and the buyer has the right to back out if during that period of time. So you can choose that as an option here. However, in many cases, the construction is still going to be being completed. It's too early to inspect the property, so we need alternative inspection procedures for the new construction. In that instance, the buyer can check the second box, waive that due diligence contingency period, which would otherwise begin at the beginning of the contract, and pursue these inspection provisions instead. Okay, and that includes you get upon written notification from seller of substantial completion. Okay, and I know that we already talked about that's a little bit of a wobbly term, but there will be notification from the seller that at least the seller believes that they're substantially complete, and at that time the buyer can do their inspections. Okay, of course that's going to be at buyer's expense. The parties can pick a time frame. We have 10 business days written in here, but you can choose a different amount, whatever the parties want to choose. Okay, and they then, how this is going to work is that there would be a written punch list that's created after the inspection or during the inspection based upon items that buyer's inspector believes to not be consistent with building codes or industry standards, or that are not consistent with the plans and specifications that had been agreed to in the contract. Okay. If the buyer does not provide that punch list, they are going to be deemed to have accepted the condition of the property. Okay. Now, of course, the seller still has an obligation to provide the property to buyer in a habitable condition. Okay, but if buyer doesn't provide that punch list, they're not going to be able to later complain about some aspect of their plans or specifications that were not completed to their liking, or that if something was habitable but not quite up to code, they would not be able to complain about that because they had their opportunity to inspect and ensure that those things were the case. Okay. Now that's probably a little bit strict. If something was not up to code and the buyer later found out, there still likely would be a remedy for the buyer. But this punch list is going to be very important for the buyer to continue to be able to negotiate with the seller. And at that point, then the seller or contractor, if they believe that that punch list of items based on the buyer's inspection is inaccurate, they think that actually everything is performed to code, everything is done as detailed in the plans and specifications, then they could take that dispute to the construction contractors board to be mediated at the construction contractors board. Okay. Any other disputes are going to be resolved according to our dispute resolution provision below. So this is sort of like an interim dispute where there's disagreement about the punch list and whether there really is something that needs to be changed. You could go to the construction contractors board to have that dispute mediated. The next section we have is on our closing date. So the closing date, you have two options. You can keep it unchanged from the sale agreement, or you can extend it, okay, or pre-authorize an extension, okay? So the second box is really an automatic extension if closing cannot occur through no fault of seller. We know with material and supply chain constraints and labor constraints that it's been taking a lot longer to build new construction than it used to. If that is unacceptable to the buyer, if they want that, the deal to close at the time that was agreed, they can not agree to let it be modified. Okay, they can check the first box and say it remains unchanged. If the seller can't deliver by that date, then the seller's in breach of the contract. Alternatively, you can build in this wiggle room for the expectation that there may be some delays, as long as those delays are through no fault of seller. If the delays are through the fault of the seller, then the seller is going to be in breach of the contract. Okay, but if you check the second box and it's because the materials or supplies were delayed, or there was a labor shortage that was out of the control of the seller, then there's going to be that automatic extension and it will not be a breach of contract. The next section is dealing with the dispute resolution. How do you deal with the dispute? So we talked earlier, if it's a dispute over the punch list items, you have the option of taking that to the construction contractors board to be mediated. Okay, but you also have all of the options laid out here. Okay, whether it be for the punch list, if you choose to do this instead, or for any other dispute that arises during the contract or after the contract. Okay, so what we say here is that for any negligently or improperly performed work or breach of contract by seller or contractors, okay, the buyer may have rights to file a complaint with the CCB. There's timelines for that. We'll talk about that here in a minute. We laid out the statute here of what those timelines are. If the parties do not resolve the disputes through the CCB, okay, then they're going to follow the dispute resolution provisions in the sale agreement. So it's really sort of an option here. You never have to solve disputes through the CCB. Okay, it's an option. There are some benefits to it. Okay, and there's benefits to it for buyer and for seller in many instances. But there's also the opportunity to use the underlying dispute resolution provisions of the sale agreement. Those provisions are, if the dispute is $10,000 or less, it would go to small claims court. If it is more than $10,000, or if it's not a monetary dispute, if it's a dispute for specific performance or something like that, you go through mediation and then arbitration at Arbitration Services of Portland. Okay, it's called Arbitration Services of Portland, but they actually have offices all over the state and mediators and arbitrators all over the state. If you are a member of PMAR, you don't go directly to Arbitration Services of Portland, you go to PMAR to do the mediation, because PMAR has a mediation program. Okay, other associations do not. we're not here in the business in this document, and you shouldn't be in the business as a real estate agent of advising your client on the best way to resolve the dispute, given that there are some options of taking things to the CCB, going directly to the dispute resolution provisions in the sale agreement, or some combination of the two. If there's a dispute, your client really should talk to their own attorney about the best way to resolve that dispute. Okay, I mentioned there often are a lot of advantages to using the CCB process. Okay, because that allows you then to tap into that bond of the contractor, should you be ultimately found to be in the right. But that's sort of legal advice to start giving, to talk to your clients about all of that. So make sure that they know where to find the information. That's why we're linking to it, and that they talk to an attorney about the best way to resolve their dispute. Now, in terms of those timelines for filing complaints to the CCB, so look at section 1 here. These are the requirements in the regulations for filing complaints with the CCB. And you'll see section 1A, 1 year after the date the structure was first occupied, or B, 2 years after substantial completion of the structure by the contractor. Okay, so for new construction, those are going to be the primary timelines. Okay, if it's an existing structure rather than new construction, okay, that's down in section 2. That's a 1 year timeline after work was substantially completed by the contractor. The next section of the document is section 18. This is our additional provision section. We've provided a lot of lines. You can add additional provisions in here if we've haven't covered something that you need to cover, or there's something you need to specify in more detail. You also can use our Form 2.2 General Addendum to add additional provisions if enough space here, you don't have enough space here. If you're using, I believe if you're using zip forms, or if you're using SkySlope, in these types of sections where you have multiple lines to type, if you run out of space, it should be bringing automatically in our Form 2.2 General Addendum to allow you to keep typing. Okay, so if that's not happening, let us know, but that is something that we set up with both of those vendors. And then the final section here is for the parties to sign the addendum, make it part of the sale agreement. Okay, just so you all know, the Construction Contractors Board website is a great resource for you. It's a great place to look up contractors, to learn about the laws related to contractors, to learn about the notices that are required, to learn more about the Home Buyer Protection Act. They've got a lot of tools and resources for consumers, for contractors. So definitely encourage you to check that out. Also, we have a lot of additional resources on our website. We have a forms email address and phone number. You can reach out to us anytime, and we'll get you the information that you need related to the forms. We also have our legal hotline. So let's say you're actually doing a transaction and you need to get a question answered. You can reach out to our legal hotline, legal@oregonrealtors.org. The stated timeline that we get back to you on the legal hotline is 48 hours, but honestly, we're averaging probably like an hour or less in getting back to people. So that could change if the volume increases, but know that you can always ask questions. You can also pop into those Friday 11 o'clock sessions to ask questions about new construction or any other form. And told you earlier about the additional resources, including that guided form. So please do check that out. So that completes my prepared presentation, but I'd love to just spend the rest of the time answering questions if people have them. I don't see any in the Q&A. I do want to keep going for a few more minutes so that we make sure everyone gets their 50 minutes worth of CE. So let me just see if any questions pop up. If not, then I can just dive into a couple of additional topics. No questions, really? I'm shocked by this. Okay. All right. Well, I think what I'll do then is let me share my screen and show you guys a little bit more from the website of things that can help you out. Oh, Q&A. Here we go. Are contractors required to have a builder's warranty for new buyers? Yes, we went through, that's in the sale agreement. There is a new construction warranty that they are required by law to offer as part of new construction. There's a section in the addendum that covers that, and the parties can indicate whether it's already been given and whether it's being accepted by the buyer. Buyer can reject it if they want to, but the contractor does have to offer it. I don't have all of the details in front of me. What needs to be included in that warranty is relatively minimal. Okay, and so it's not an extremely strict standard of what needs to be in there, but it does need to be provided. Thanks for that. A template would be nice, Tracy, for what? The contractor warranty? I believe that there is, I think there may be a template for the contractor warranty. Okay, I believe there may be a template for the contractor warranty with the CCB. So I'll look into that. I definitely encourage you to check out their website though. I know they have a lot of information about sort of what the minimum requirements are. And I thought that they had some kind of, let's see, just on the website here. They got a lot of information. They may not have a template. I agree. It would be cool to have that. That's probably it's probably a better thing for the CCB to do than for us to do through the Oregon Realtors forms. But I'm going to make a note of that and reach out to the Construction Contractors Board to see if that's something that they're working on or if they maybe would want to partner with us on. So thanks for that. That's a good suggestion. All right, other questions? Yep, no problem. Okay, well, I think we've hit our 50 minutes, so I think we're good on the CE credit. So I think what I'm actually going to do is just hang out for a bit, see if other folks have questions. Has anybody, just curious, pop in the chat, has anybody used the new construction addendum? Yep. And curious how, oh, good, MG, that's great. How did it go? Tell us how it went. That's the other thing, everyone, we love your feedback and we take it very seriously. So if you do have any suggestions on any of our documents, we will always consider them, get back to you, let you know whether we plan to make those updates. And then if we think it's a good suggestion, we'd be inclined to make a change. On our website, there's if you go to the contact us page, there's actually a place where you can give feedback on the forms. It takes you to a Google form where you can select the form that you want to give feedback on and write in your feedback. And then that populates a spreadsheet for us that we use to review and consider any future updates. So I encourage you to do that. All right. Any other? Just going to hang out and see if anybody has any questions. Oh, let's see. Okay, great. Yeah, thanks for that, MG. Appreciate it. Gosh, all right. All right, well, I'm going to keep hanging out for a few more minutes. I think in the meantime, I will share my screen and go back to the Oregon Realtors website, show you guys some more things you can find there. feel free to, folks who want to, feel free to hop off. You've gotten your 50 minutes here. Or I think that's acceptable. Katie, tell me if I'm wrong. So every week we put out a tip on forms. Okay, tip of the week. Hopefully you get our forms weekly email. But if you ever want to review those tips, we have them all logged here. So click this button and you'll get the forms tip of the week. Okay. So we got quite a few there. We're going to do those every week. So over time, you're going to have a lot of tips that could be helpful to you. Also, we have our FAQ section on the website. This is a good place to get answers to some of your basic, questions about the forums, how to use them, where to find them, what vendors we work with, what some of the details of those vendor relationships are, including our member benefits related to the vendor platforms. So do check that out as well. And then let's see, I mentioned the contact page. So here's that. If you have that suggestion, you click here and it'll take you to this form that you can fill out, get a little bit of background information, kind of give us a little bit of information on what perspective you're coming from, what vendor you're using, and then you can provide information. I can't go forward because I didn't fill it out, but provide the feedback that you have on the particular forms. All right, well, I guess we'll just wrap it up for today. Thanks, everybody. Appreciate it. So glad that you're here. Have a great weekend. Have a great holiday. And we will see you next time for our Friday webinars. Take care.